So, again, a very good morning to all. So, this is the second subject that we are going to study today. The name of the topic is, of course, corporate restructuring, insolvency, liquidation, and winding. So, out of this, the 50 marks topic, that is the liquidation, insolvency, and winding up, that I'll take. Dushyant sir will take the corporate restructuring part. So, I'm going to begin with the insolvency, liquidation, and winding up that we should ideally finish in a month's time. That is the ideal time, of course. That may take a little longer than that because, to the best of my knowledge, you haven't studied the insolvency, liquidation, or winding up before, right? So you have only had an introduction in the executive as to what is winding up, so on and so forth. But that is again very very basic, so we might require little more time, but probably by the first weekend of January we should be done with that. Now, as we are going to study the corporate restructuring, insolvency, liquidation, and winding up, what do you mean by corporate restructuring? Or rather, means before discussing restructuring is changing the structure, restructuring. So, what do you mean by corporate structure in the first place? Only mergers, amalgamations, internal restructuring. Okay, what sort of internal restructuring you are talking about? Buybacks, yes. Reduction of share capital, that is also possible. What else? Basically, what do you mean by corporate structure? That is the basic question which I have for you. Only the share capital? Management. Okay, so what do you mean by management? Board of directors. Okay, so if let's say two of the directors resign and two new directors are appointed, is it a part of corporate restructuring? So can we call that restructuring because the structure is changing? So what will you call restructuring? Suppose registered office of the company is shifting. Is it corporate restructuring? No. Okay, I will go even one step prior to that. So what are the characteristics of a company? Like what are the identifying traits of a company on which you say that this is a company? Yes, separate legal entity, agreed. Yes, agreed. Separation of ownership and management. Sorry? Perpetual succession, yes. Limited liability, yes. Of course, there could be a company with unlimited liability also, but otherwise, the liability is limited. Have we discussed the concept of limited liability? No. So, what do you mean by limited liability? Okay, what do you mean by unpaid amount? Unpaid amount of face value or the entire unpaid amount? Entire or face value. For example, the share of rupees 10 was issued to a person, and rupees 5 is paid up. So in this case it is very clear that his liability will be rupees 5, which is remaining to be paid. But suppose the share of rupees 10 was issued at rupees 12 and only rupees 5 is paid up on that particular share. So will it be 7 or will it be 5? Why? To the extent of face value. That is what we have learned since 11th standard, right? That amount which remains unpaid on the face value of the shares, that is the liability. Is that correct? The answer is actually no. So if you look at the entire gamut of the legislation now, that the Insolvency and Bankruptcy Code as well as the Companies Act, then you will come to understand that the entire amount which remains unpaid on the share capital is the liability of the member. So that is the one thing which is hardwired in our brains, that only the amount unpaid on the face value is the liability, and that person is not directly liable for share premium. That thing we'll have to erase now. So entire amount, the first answer which you gave me was the correct answer, that the entire amount which remains unpaid on the shares is the liability of the member. The earlier concept that only that thing which is unpaid on the face value, that should be deleted from our minds, and you must always remember that. So again, coming back to what do you mean by corporate structure. So these are the characteristics of the company. So the company is shown to be a company by its registered office, because that is where the company lives in a, I mean, so as to say, the company lives at its registered office. So that is the registered office. The company carries on business through the board of directors, through senior management, through other employees, and the company, there are some shareholders who have given the money to the company, and in return of the money which they have given, they have gained some rights. They are not the owners of the company, but they have gained some rights over the company. So those will be another sort of stakeholders. So these are the means, can we call this as the structure of the company? Means this is the structure, that there are shareholders, directors, employees, management, and uh, a registered office to show. Because if we say yes, then the next question arises, that whether the change in directors is corporate restructuring, whether, let's say, change in shareholders, for example, Mr. X transferred his shares to X, to Y and Z. So is that a part of corporate restructuring? The way we understand corporate restructuring is only in the context of section 230, that compromise, arrangement, amalgamation, merger, finish. That's it. That's the corporate restructuring. That is not true, because as we discussed earlier, there is some internal restructuring also. There is buyback, there is a reduction of share capital, there could be even increase of share capital. So again, we understand that even the internal restructuring as a reduction of the existing liability. Like when we say buyback, the share capital will be reduced. When we say reduction of share capital, the paid up share capital will be reduced. When we say extinguishing the authorized share capital which is not agreed to be paid up, even the authorized capital will be reduced. But what if I'm increasing all of this? Whether issue of shares is a part of corporate restructuring, whether increase in the authorized paid up share capital is a part of corporate restructuring. The answer is yes. Although we don't understand it to be so, we must always keep this at the back of our mind. We must be able to pinpoint to the structure of the company, and then any change in that structure will amount to restructuring. Then it does not matter how that change is coming about. In my opinion, even the shifting of the registered office could be said to be corporate restructuring, because after that shifting of the registered office, maybe you will be subjected to different stamp duty, different local regulations. So it's a change in the operation of the company, which results into which has some future impact also. Can we develop a test that anything which is directly related to the company, any change in that will amount to corporate restructuring? Again, the answer is no, because there could be no thumb rule. For example, the takeover of a company. shares of a shareholder are being purchased by someone else. Is the company affected in any way? The answer is no. The company will not receive the amount. The company always had a shareholder, it will have a different shareholder now. So that is the only change as far as the company is concerned. But still, we study takeover in corporate restructuring because there is a change in control of the company. So, whenever there is a change in the board of directors, which is effected because of a change in control, that may amount to corporate restructuring also. So, the point I want to drive home here is that don't confine your mind of means whenever you say the word corporate restructuring, don't confine it to compromise arrangement, amalgamations, and mergers. There is a lot of other changes which could happen. Change in the alteration of the object clause, is that uh, is that a part of the corporate restructuring? The answer is yes. So any change to the fundamental characteristics of the company will be called as corporate restructuring. And the fundamental characteristics of the company will be the characteristics with which the company is identified. For example, the share capital, the owners of the share capital, the persons who are controlling the company, the place, the situation of the company, the objects which the company can pursue, the name which the company carries. All these things are one way or the other a part of the corporate restructuring. Even the increase in the number of shares by way of issue of shares, that is also a part of corporate restructuring. Means whatever the structure is existing today, you are trying to change that in one way or the other. So please do not hold this narrow view that only mergers, amalgamation, and anything which looks amazing and sounds awesome is to be called as corporate restructuring. No, even the most mundane activities like shifting of the registered office from one place to the other. In some cases, when it is within the particular city, only board resolution is required. So maybe in that case, you won't call it corporate restructuring. But when you are shifting from one state to the other state, or from the jurisdiction of one ROC to another ROC, then that is something which will significantly impact you. So that could be a part of your corporate restructuring also. So the all the care, all the love which you show for a corporate restructuring assignment, the same care, the same degree of love should be shown to those mundane assignments also. So don't be under the impression, although in our corporate restructuring, again, the only thing they talk about is the mergers, amalgamation, so on and so forth. But we should not be fooled by what they are saying. And although you will write in your exam that this is what corporate restructuring is, always have this at the back of your mind that the structure of the company is something which is amorphous. Amorphous means something which cannot be ascertained with certainty. So in one case, change of one particular aspect or one particular characteristic may amount to corporate restructuring. In some cases, it may not amount. But of course, for the purpose of our syllabus, we'll be confining ourselves to section 230 to section 240 only. Now corporate restructuring is done. What do you mean by insolvency? Basically, what is bankruptcy and what is insolvency? That is the most important question. Okay. Okay, so you are saying that insolvency is a voluntary action and bankruptcy is an action which is taken by your creditor, means you are forced to do that. No, actually. So insolvency is basically the state of not being able to repay what you owe. Means I have a debt. I means I have borrowed some amount from someone and I'm not able to repay that. That is the state of insolvency. Insolvency may lead to bankruptcy. Bankruptcy is the term for individuals and partnership firms. Means as far as the insolvency and bankruptcy code is concerned, that the bankruptcy part is only with reference to individuals and partnership firms. As far as the companies are concerned, we need to go for liquidation. We can't go for bankruptcy. So insolvency is the first question, that can you repay your debt? The answer to that is no. In both the cases of the firms, the individuals as well as the companies. The second level question is what should be now done to you? That would be The answers would be different. In case of persons and firms, there would be bankruptcy, where the person or firm will be declared to be bankrupt by the Debt Recovery Tribunal, that is DRT. And in case of companies, the NCLT will start the liquidation process. Means if the insolvency resolution fails, then there would be the liquidation process, because that is why the nomenclature is developed in a certain manner, that insolvency resolution process, IRP, that you must have already heard. So what do you mean by resolution? Resolution is trying to find a solution. So you are trying to find a solution to your insolvency. So that is your inability to pay debt, and you are trying to redress that. आप पैसे नहीं दे पा रहे हो, तो आप पैसे कैसे दे, ये जो आप solution ढूंढने जा रहे हो, that is your resolution process. And after that resolution process, if it is understood that the company is just not in position to repay anything, then the company will be wound up. That would be your winding, means that will ultimately go into liquidation or winding up, both will be the same, where the assets of the company are being sold to realize the money and pay that to the creditors. After the entire process is over, after all the assets are sold and whatever money is distributed, there would be a dissolution of the company. So dissolution means the end of the life of the company. Now tell me one thing, after the winding up, means suppose the winding up proceedings are over. Can I restart the business of the company? So there is X Private Limited. X Private Limited owed 1 crore rupees to, let's say, Mr. A. Mr. A started the insolvency resolution process. There was no resolution plan which came forth. So the company went into liquidation. The assets were sold. Mr. A was paid, let's say, some 40 lakh rupees for the 1 crore amount which was owed to him. Now, Mr. A says that after the entire liquidation process is over, I want to buy X Private Limited. Is that possible? No? Why no? No problem. X Private Limited does not have any asset, but X Private Limited is still there on the register of companies. So Mr. A says that I want to buy this company now. Can he do so? Yes. Or let's say after the entire liquidation is over, the members of X Private Limited, now they come forward saying that we want to revive the company and start the business again. Can they do so? Yes. So in all cases, till the order of dissolution is passed, then you can still revive the company. And that revival could be by anyone, maybe the existing member, maybe someone who wants that company, anyone. Now, why would someone want to buy a company which has already gone into winding up? Can you think of some reasons as to why I would be willing to buy a company which is already in winding up? Exactly. So if I am in same business and I want to have or I want to start that business and I want to have an entity which is existing for a number of years, so that I'll have a ready track record to show that I was existing for so many years. That is reason number one. Reason number two, suppose the entity which ultimately went into winding up was listed at one point in time. Let's say that company was later on delisted for default in payment of the listing fees. Still, it is possible that I can persuade the stock exchange to allow me to list the company again by simply making the payment of all the fees which are due. So, in that case, it will be very easy for me to get control of a listed company. So, that would be another reason why I would like to buy that particular company. Third reason, suppose I already have an existing profitable business, then I will buy this company just for the accumulated losses this company has. So I will buy the company, I will maybe merge that company in my company, and then I will start claiming the unabsorbed depreciation or the accumulated losses which that other company has. And whatever profits I am earning, effectively I'll not be required to pay any tax on that. So these are various reasons why would you like to do that. Means the point I want to drive home here is that In liquidation and winding up, these processes are merely for the sale of assets and realizing the amount which could be realized. After that also the company can restart the business or someone can acquire the company. The ultimate stage is of dissolution. After dissolution, no one can do anything. When the company is dissolved, the name of the company is removed from the register of members. Then you can't do anything. Then you can't revive the company, then you can't start the business, then you can't sell the company. Nothing could happen. Now, are there any other ways in which you can directly go for dissolution without going for winding up? Uh, a wrong business which is not legal. Illegal business. That is a ground for application for winding up. I am saying that without going for winding up, is there any way? Is there any way that you can directly dissolve the company? If I sell all the shares, there would be someone who will buy all the shares. S- Sorry, removal of the name of the company. Exactly. So you were saying significant accounting transaction is a test for a dormant company under section 455. Uh, mm, no. See, that is so if the company is entirely inactive, then the ROC may strike off the name of the company. That would be an action available to the Registrar of Companies. For example, I incorporate a company and within a period of 180 days, I don't file a declaration regarding commencement of business under Section 10A of the Companies Act. Then ROC gets the power to strike off the name of the company from the register of members. That these are the powers with ROC. What I am talking about is section 248 subsection 2. 248 subsection 2 says that for all companies except a section 8 company, there could be a voluntary means application for voluntary strike off. Once all the debts and liabilities are extinguished, then you can make an application for striking off the name of the company. Once that application is made, then great, your company can be removed without winding up. Because whenever you make that application, what you need to show is that there are no assets in the company. All the assets were already sold, and the share capital is represented only by the accumulated loss. There is not even a bank account operating in the name of the company. Then you can get an order for removal of the name of the कंपनी. सो देयर द जो पूरा वाइंडिंग अप का प्रोसेस था जिसमें एसेट सेल करने थे, मनी रियलाइज करना था, क्रेडिटर्स को पे करना था, वो आप खुद ही करके जा रहे हो कि हमने सारे एसेट बेच दिए, सारे क्रेडिटर्स को पे कर दिया, अब हम बस हमारा शेयर कैपिटल है एक हाथ पे और दूसरे हाथ पे हमारा अक्यूमुलेटेड लॉस है, बैंक अकाउंट भी नहीं है हमारे पास, जस्ट रिमूव द नेम. So that is the procedure for not following the entire winding up process and then simply going for dissolution of the company. In that case also the name is removed from the register of members. Only point is that it could be restored within the next 20 years. That is the only option which is available to other persons for doing that. Now, uh, what we are going to do is we will first discuss what topics are there, and then today we will start with the reading of the BLR, so the Bankruptcy Law Reform Committee report. So prior to that, just to give you a brief idea as to how the entire bankruptcy and insolvency has evolved. The bankruptcy procedure was always there for the individuals. So there is a reference in your module also that since in the 1500s also there were legislations for the bankruptcy of an individual, means where the individual is unable to pay the debt. What to do in that case? Earlier, it was always that the creditor got a right to individually take that amount. For example, Mr. X is the person to whom all of you have given a loan. Then Mr. X is unable to pay his debts. So the loans given are to the tune of 10 lakh rupees, and the person has that Mr. X has assets only worth 5 lakh rupees. Then the creditor who went to Mr. X first demanding for repayment can take his full money and leave whatever remains to the others. For example, the person who went first had a claim for rupees 3 lakhs. So he can realize his 3 lakhs from Mr. X and walk away with his entire money. The person who went second will, and with a claim of perhaps 2 lakh rupees, he will get his entire 2 lakh rupees. And the rest won't get a single penny. So there was no collective administration of assets. जो पहले पहुंचा उसने अपना क्लेम एनफोर्स किया और जितने एसेट्स थे उसमें से जितने उसको चाहिए थे उसका पूरा क्लेम था वो पूरे एग्जॉस्ट कर लिए. सो बाकी जिसके लिए अगर कुछ बचा तो छोड़ दिया, नहीं बचा नहीं छोड़ दिया. There were even provisions which claim that if you are a debtor to someone and if you are not able to repay that, that person can even seize your body. That is your person. Means he will make you his slave till he thinks that his debt is repaid. Then you will be required to do whatever he says. He can imprison you, he can make you work in his fields, he can make you do any of his chores for as long as he wants. These were the provisions. सो एक क्रेडिटर के पास जाओ उसको मीन्स उसने आपको इम्प्रिजन किया तो इम्प्रिजन हो जाओ, काम पे लगाया तो काम करो, देन द अदर क्रेडिटर विल कम एंड टेक योर पोजीशन. एंड वी कांट इवन कंसीव दिस इन टुडेज वर्ल्ड कि अगर सम मीन्स यू ओ मनी टू समवन, you are not able to repay and the person is taking you home to work as his or her slave or servant. That is not even imaginable in today's circumstances. However, this was a provision in the early insolvency laws. What happened later on was that the entire concept of collective administration of assets was evolved. मीन्स उसमें क्या था कि सपोज 5 lakhs के एसेट्स है, तो पहले दो लोगों को ही आपने पूरे 5 लाख दे दिए, बाकी तीनों को कुछ दिया ही नहीं. इज दैट अ फेयर थिंग? द आंसर इज नो. बिकॉज परहैप्स ये दो जो डेट्स थे उनके रिपेमेंट ड्यू थे, इसलिए वो क्रेडिटर्स चेक करने के लिए आए. सो शुड द क्रेडिटर कीप ऑन चेकिंग द डेटर ऑल द टाइम? द आंसर इज नो. इट शुड नॉट बी डन. So there came this concept of collective administration of assets कि उसके जितने भी assets है they will be administered for the collective benefit of all the creditors. So उनको 10 लाख ड्यू है, asset 5 लाख के है, तो 5 लाख के asset 5 लाख को बेच दिए और हर एक क्रेडिटर को उसका लेट से अगर 2 लाख का क्लेम था तो उसको 1 लाख दिया 50%, because there are only 50% of the assets. So everyone got 50% of his claim and everyone suffered a loss of 50%. So that is the concept of collective administration of assets. Even under the insolvency and bankruptcy code, whenever you start insolvency resolution process, the application, which could be made either by the corporate debtor himself or the financial creditor or operational creditor. So whenever these FC and OC are making this application, will they get any preference because they made the application? The answer is no. They will start the entire insolvency resolution process. However, the process in that process, the assets will be collectively administered for the collective good. I mean, there is a committee of creditors to take all the decisions, and every creditor will get a fair or rather equal treatment. Equal treatment provided that he belongs to that particular class. Means if there are secured creditors, they will be treated like secured creditors. If there are operational creditors, they will be treated like operational creditors. If there are financial creditors, they will be treated as financial creditors. So this is how the entire administration process would work. So the provisions regarding winding up and this entire collective administration of assets were introduced for the first time in the 1908 Consolidation Act, the English law which related to the consolidation of the various provisions of the Companies Act that contain this provision for the first time. So I don't think that part is there in your module, so I will provide you additionally in the form of notes. So I think Janet DN has written a very good book on the insolvency resolution process. So I will refer you the name of the book. So that is an additional reading which you can do to understand the UK provisions. Means it is not on Indian provision. As far as the Indian provisions are concerned, first of all, there are not a lot of reference books, and the ones which are there, they are not comprehensive and they are not good enough. Means at least I did not like them personally. So by and large, we will confine ourselves to your module, but there are of course a lot of additional things which have happened because your module contains provisions only till June. But there are a lot of things which have happened after the month of June. So those things we will additionally do, and as always we will first read through the module. But only difference same as in DD is, after the completion of each chapter I will give you a summary of the chapter separately. Means I will give you the highlighted module also, the summary and additional notes they will be given to you separately, so that it will be easier for you to go through that. Because even this insolvency, liquidation and winding up part, that is also about 290 pages. And then there is the first part of CR, which is for 50 marks, and that is again for some 400 something pages. So we will of course begin with the insolvency, liquidation and winding up, the 290 pages part, that is again for 50 marks. So practically speaking, this is a more scoring part, because you need to study less, and the legislation is still fresh. So it is a modern legislation written for modern times. Hence, it will be easier for you to remember, easier for you to understand, as compared to the entire compromises, arrangements, understandings, and other provisions. So, with this long introduction, let us at least go to what uh, your syllabus is going to be all about. So, insolvency and bankruptcy code, they always keep on harping the fact that it's a code. It applies to the individuals, it applies to the partnership firms, it applies to the LLPs, it applies to the corporate persons. Oh, yes, one more point. Corporate restructuring. We discussed the word restructuring and structuring, but what do you mean by corporate? Okay, so in that word corporate restructuring, what will you study as far as the word corporate is concerned? Companies will be covered. Agreed. Okay, what sort of body corporates? And how come individuals? I'm talking only about the corporate restructuring. I'm not talking about the insolvency part. Yes, so entities which have a separate legal status, can you specify what sort of entities will be there? Companies, yes. LLPs, yes. Will you study the corporate restructuring of a foreign company? It's a company, right? Yes. And if yes, then which definition of foreign company will you use? There are two definitions of foreign companies, right? In clause 42 of section 2 and in 379. So in the word corporate, you are going to include only the companies and the LLPs. There are other types of entities which have separate legal existence, but they will not be a part of your syllabus here. Because in insolvency, liquidation and winding up, we will of course be studying the provisions for LLP as well as for companies, because under the insolvency and bankruptcy code, LLP and company, they are both are treated as corporate debtor. So the provisions will remain the same for both the LLPs as well as company. However, on the other hand, whenever we talk about corporate restructuring, section 230 onwards, then 230 to 240 will be applicable only to companies. Companies will include foreign companies for the purpose of section 234, and in 234 you may also include a foreign LLP also. But whether the Indian LLP will be covered under 230 to 240, the primary answer is no. But Chennai NCLT, in one of the orders in Cube Cinemas Limited, they stated that even Indian LLP can merge with an Indian company. So that was a landmark decision given by the uh, that Chennai bench, and which is not something which was seen before in the Indian context. So that is another point which you must always remember, that whenever we are talking about corporate restructuring, we will be basically dealing with the companies and LLPs only. Whether a foreign company will be a part of it or not will be dependent on whether it is a foreign company for the purpose of section 234. The two definitions which we saw, that the foreign company under clause 42 of section 2 and under section 379, both will not be applicable, because a company which is a foreign company for 379, or for that matter 242 also, that may very well be a company which is incorporated outside India and which only has a business presence in India. So what restructuring will you do of its Indian business? The answer is nothing, because it's not in India in the first place. So there would be no corporate restructuring of such a company, and hence there would be no point in discussing those provisions except in the ambit of section 234. Now, with that, let us come back to the insolvency and bankruptcy code. So, as we discussed, insolvency is a state of not being able to repay what you owe. Bankruptcy is a state of an individual or firm being declared to be bankrupt. Means it's a legal process, it's the end of the legal process where it says that okay, this person is bankrupt, he does not have any assets whatsoever to repay whatever his debts are. So that is the declaration of bankruptcy. Now it is always stated that it's a code. The moment we use the word code, we understand that it's a consolidating and amending legislation, and it should encompass everything. However, the Insolvency and Bankruptcy Code still relies on a lot of other legislations to make it operable. Means it does not contain a lot of provisions which are contained in other legislations, and those legislations are required to be taken into account to go for this entire insolvency resolution process. So this is something which you should always remember. So here they are giving an introduction that there are multiple overlapping laws and adjudicating forums dealing with the corporate financial failure and the insolvency of companies and individuals in India. So there were different laws for individuals, there were different laws for the companies. So now that is being combined into only one legislation. Is it something which is revolutionary or radical? The answer is not at all. Merely because it is being combined in one legislation does not mean that it has become revolutionary or it has become radical. The only thing which is new is that the insolvency laws, the provincial insolvency laws which were applicable prior to the insolvency and bankruptcy, which are actually still applicable because the part relating to the individuals and firms is yet to be notified. Those laws were very, very old. Means they were the Presidential Towns Insolvency Act and the Provincial Insolvency Act, and they were passed well before 1950. Means they were more than 100-year old, and they were later on replaced by, they are sought to be replaced by an insolvency and bankruptcy code which is a modern legislation. So that is the point, that is that something which is unique, is that something which is radical? The answer is no, because for individuals and firms, they are already stating that the DRT will take care of it, and for companies and LLPs, NCLT will take care of it. So the tribunals are as it is different. Only thing is that that 100-year law is replaced by a modern legislation which is quick, which is efficient, and which speaks the language which the today's time speaks. That is the only good point as far as these legislations are concerned. So that is something which we must always remember whenever we are talking about it. The existing framework is consolidated by a single law is created for insolvency and bankruptcy. It aims at companies, partnerships, LLPs, individuals, and any other body which the central government may specify. Central government has not specified anything else. So whenever we use the word corporate debtor, we will include the LLP as well as the company. So this is something which we'll always have to remember, that in the insolvency and bankruptcy code, company and LLP are on the equal pedestal. There will be no different treatment for companies, no different treatment for LLPs. IBC will apply both to LLPs as well as companies. So the usual disclaimers they have given, that the examination standards are set very high, this and that, this and that, this and that. The only thing which you should remember is the insolvency, liquidation, and winding up is for 50 marks, and it would be much easier to study and much easier to score in as compared to your corporate restructuring part. There would be only a few case laws to remember. That would be the only problem, but that volume of case laws will still be less than the volume which you will have in corporate restructuring. Now, tell me one thing. As we were discussing corporate structures and everything, like an individual has certain freedoms, and like freedom of expression, uh, freedom of movement. So these are the freedoms which an individual has. So for a company, what sort of freedoms are required? So if I am a company, what sort of freedoms or what sort of rights should I have? Fundamental rights are available to companies or not? Answer is no. Fundamental rights are available to natural citizens, natural persons. Some of them are available to citizens, some of them are available to non-citizens, but every single person has to be an individual who is to claim that fundamental right. Okay. hmm Broadly speaking, there are three fundamental freedoms which a company should have: freedom to incorporate, freedom to compete, and freedom to exit. So, freedom to incorporate is given by the Companies Act 2013, which allows the company to be incorporated after complying with certain standards and after getting certain registrations. Freedom to compete, what all you were saying, that freedom to enter into contracts, freedom to operate bank accounts, everything will come as a part of the right to compete. Because only because you want to compete in the marketplace, compete for the resources, that is why you are going to conduct the entire business. Opening bank account, freedom to trade, freedom to enter into transactions, uh, any other freedom to engage personnel. So all will be a part of this freedom to compete. Freedom to compete is again given by the Companies Act 2013 as well as the Competition Act 2002. We have spoken very briefly about the Competition Act 2002. Only thing that you need to remember is that it repeals MRTP and it allows the companies to compete freely without anyone abusing their dominant position. So it is not a problem to have a dominant position. The problem is to abuse the dominant position. So, for example, Maruti Suzuki. Maruti Suzuki enjoys a dominant position as far as the car market is concerned. Almost every other car being sold in India is a Maruti Suzuki. So whether CCI will take action against Maruti Suzuki, the answer is no, as long as they don't abuse their position. If they abuse their position, yes, action will be taken against them. So the third freedom is the freedom to exit. Means if your business is not working, then you should be in a position to exit your business in a timely manner, and such exit should not affect your other businesses or any future business. So this third freedom is being given by the Insolvency and Bankruptcy Code, which allows you to exit your business, which allows you to liquidate your assets, and allows you to start different business without there being any um, failure recorded to your name. You have read section 164, 167. Have you read anywhere in those two sections that a person who was a director of a company which went into insolvency or which went into liquidation is debarred from being a director or continuing as a director? The answer is no, because there is this freedom available to you to exit that particular business and start whatever you want again. So that is the importance of this freedom to exit without there being any blame on your side. If your business has gone down, then you should be in a position to exit that business and start something new. So that freedom is being given by the insolvency and bankruptcy code. That is why it's such an important piece of legislation. So the syllabus is basically the historical background. What are the pillars of IBC? Pillars of IBC means what authorities are established. For example, IBPI as a regulator, the insolvency professional agencies as the agencies which will license the insolvency professional, the insolvency professional himself, the adjudicating authority, that is NCLT or DRT as the case may be, the information utilities are used, so on and so forth. How many information utilities are there in India? There is only one, NSEL, National, no, NESL, sorry, National E-Governance Services Limited. So that is the only information utility which is operating in India till date. Of course, when we will go to the syllabus, we will discuss their functions in detail. But what they are going to do is they are going to collect information and they are going to make the information available to as many people as they want. They means the people want. Oh, then what are the key definitions? What are the key concepts? Insolvency, initiation, resolution under section 7, 8 and 10. Initiation and resolution 10 is basically application by the corporate debtor, and there is also a process of voluntary liquidation where even though you have not made a default, you can still make an application for insolvency for liquidation of the voluntary liquidation. So petition for CIRP, like what is the process? Who can make this petition? What is fast track CIRP? Or is there any different criteria? If yes, what is the criteria? So all these points we will see in this chapter. Roles, functions, and duties of IP, IRP, or RP. IP is insolvency professional, IRP is the interim resolution professional, and RP is resolution professional. So what duties these individuals have? Like in all in many of the cases, you will be in a position to start as a resolution professional. Do you know about the course which is being run by IICA, Indian Institute of Corporate Affairs? So it is being run in jointly with IBBI. If you undergo that 2-year course, you can directly become a resolution professional. There is no need for you to wait till you complete 10 years of continuous practice. You can directly enroll yourself as a resolution professional even before you complete your 26 or 27 years of age. It's a 2-year program. 1 year you are supposed to live in Delhi and attend the classes in Delhi. The next year is spent in internships. The internships are with law firms, the insolvency professionals. The internships are also with the IBPI, the stock exchanges, RBI, and other regulators. So it's a very good program, very intense program, of course. But if you want to pursue your career in IBC, then it's a very good avenue where you can start immediately as a resolution professional. You need not wait till you complete 10 years of practice. Even after completing your CS, you can enroll for that program and complete that. CACSCWA qualification is the minimum requirement of that course. So once you become a member, once you complete your articleship, then you can easily make an application. And if you want to go into the insolvency resolution world, then it will be a great ladder. There are intensive classes, discussions, intensive classes, discussions, then a lot of internships where you can build some good contacts and forge ahead in this field. Resolution strategies. Resolution strategies basically means how do you resolve that particular insolvency which is happening. Convening and conduct of meetings of committee of creditors. Committee of creditors becomes the deciding body. The moment there is a default on debt, the person to whom the debt is owed should be put in control, and equity should not continue to remain in control. That is the logic behind the entire insolvency and bankruptcy code. Then there is preparation and approval of the resolution plan. Resolution plan is the plan which you put into effect to make sure that the company comes out of insolvency. So what is the timelines for these? Have you read them anywhere? 180 days, not 6 months. So 180 days or 270 days to come up with a resolution plan. Your resolution plan may then operate for a period of 2 years, 3 years, that is perfectly permissible. Means you will come up with a resolution plan in that resolution is in that insolvency resolution period, but your resolution plan could contain proposals which will be operative for next 2 years or 3 years. That is also perfectly permissible. So always have this concept clear in your mind that insolvency resolution period, the duration of the IRP and the duration of the resolution plan will always be different from one another. That is the point which you should always remember. So there we will discuss the contents of the resolution plan, that how do you submit, how who approves, how they approve, what criteria they use, how to write a good resolution plan, what are the ingredients in a resolution plan, so on and so forth. Chapter 20 and 21, they are kind of boring because they will deal with individuals or firms and how you deal with that. So that is there. Debt recovery and surfacing. So debt recovery is something which has been the hot topic of discussion in the country for years. We started way back with SICA, Sikh Industrial Companies Act, in the year 1985 to cure the Sikh industrial companies. The problem was, first they applied the criteria of erosion of net worth. Then they had to wait, means that industrial company which wanted to make an application under SICA. First, it had to be an industrial company. Second, it had to be registered for a minimum period of 5 years. So these were the two problems that when the cases came before SICA, the companies were almost dead. There was no chance of revival of those companies. There was no chance of promoting a healthy exit option to the entrepreneurs. That was the problem. If I am a service organization, can I go under SICA? The answer is no. You had to be an industrial company to qualify for application under SICA. So that was the first problem. Secondly, the SARFACI, the securitization and reconstruction of financial assets and enforcement of security interest act, that was passed in the year 2002. Prior to that, recovery of debt due to banks act was passed in the year 1993. All these legislations, although they were quite sound in their own regard, they were not effective enough, that the companies which borrowed the funds, they were still able to bypass these legislations, bypass these provisions, and they were able to compromise on the repayment ability and jeopardize the shareholder interest, only to pursue some short-term profits. So these are the legislations that we will discuss in that particular topic. Means why all these legislations failed and why the IBC may succeed, that we will discuss in that particular chapter. The cross-border insolvency. Now what do we mean by cross-border insolvency? Means I have a company in India and my parent company is in, let's say, USA, and I also have two subsidiaries in Singapore. Suppose my Singapore entities are not able to repay the debt. What would happen? Means will the insolvency process start as per the Singapore law, or will even the holding company in India will be liable, or even the ultimate holding company in USA will be liable? So that is the problem, that there are now in India and rather everywhere in the world, you don't really find a local company. All the companies are global companies, that they have assets spread everywhere, they have subsidiaries everywhere, and it is very difficult for an individual to keep track of everything and make sure that the insolvency proceeds accordingly. So what would happen if the insolvency is commenced against the Indian company in India and the assets of the Singapore companies are sought to be sold? So that is another question which is required to be determined when we are dealing with this problem of cross-border insolvency. At this moment, the report was submitted on the cross-border insolvency. I think this year, early this year, sometime. the report was submitted and the report is being discussed, but there is no provision in the current insolvency and bankruptcy code to deal with the cross border insolvency. So what they now do is they apply the local law of every single state and they try to take out whatever they can. That is the current practice which is happening. Liquidation on or after failing of the resolution plan. So resolution plan, if it is not working, then you will go for liquidation. That is quite obvious. Now next is a voluntary liquidation. In voluntary liquidation, although you have not made any default, you want the company to be wound up by the incident. So that is the concept of voluntary winding. Now, I think we have discussed this a little bit earlier, that what is the status of the winding up provisions under the Companies Act? The company still has its? Yes, it is a separate legal entity, no doubt about that. So, as we said that for inability to pay debt, you will be now required to be dealt with under the Insolvency and Bankruptcy Code. So, what is the point in having the binding up provisions under the Companies Act? Whether that section is repealed by IBC, the answer is no. That provision is still there. So, why do we have that provision? That is the question. Because there are some grounds like acting against the sovereignty of the state, or for that matter when it is just and equitable to wind up the company. All these grounds are not covered in IBC. IBC simply says that non-repayment of 1 lakh rupees, that will start the corporate insolvency resolution process. What about the company posing a threat to the sovereignty of India? What about it being just and equitable to wind up the company? Those things are not contemplated in insolvency and bankruptcy code. So for that, for all these applications, suppose the registrar wants to file an application for winding up, can he do so under the insolvency and bankruptcy code? The answer is no. He is not a financial creditor to file that application. So what would happen is he will take a recourse under the provisions of the Companies Act. But unfortunately, the sections were notified way back in the year 2014. Till date, there are no rules. So it is very hard to operationalize those sections. So unless and until you have rules for operationalizing the section, it will be very hard for us to actually operationalize that. So in this chapter, we will just see the legal provisions, what are there in the act, and then we will have a look at some of the case laws as to what do you mean by just and equitable, so on and so forth. Lesson wise summaries, I don't think we need to check now. Let us now go back to the Bankruptcy Law Reform Committee report. We will first read the summary and then we will start our module. Now, what do you know about the Insolvency and Bankruptcy Code? Mm-hmm. What else? So, as we discussed, there is IPPI. There are insolvency professional agencies which are set up by ICSI, ICEI, and ICMAI. Then there are insolvency professionals, the people who are licensed to be insolvency professionals and act as IRP, IP, or authorized representative of the financial creditors in the meeting of committee of creditors. Then there are creditors. In creditors, you have financial creditor, operational creditor, and other creditor. So even if I am not a financial creditor or an operational creditor, will it mean that my debt will not be repaid? The answer is no. You will be treated as an other creditor. You have to make a claim. And once the resolution professional accepts your claim, then whatever the claim is, the payment will be made to you for the same amount. Now, these are the broad uh, provisions of the Insolvency and Bankruptcy Code. But now, let us go back to the Bankruptcy Law Reform Committee report, which introduced this entire subject, because the committee reports are often constituted to be an external aid to interpretation. So, if there is any ambiguity in the legislation, the courts may rely on these committee reports to understand that what the lawmakers wanted to enact in the first place. So that is why these committee reports are extremely important. Have you read any committee reports before? Oh, okay. So everyone has read JJ Reddy committee report. Means, the why I'm asking is, do you know how to read a committee report? No. Let me tell you. So, see, usually whenever there is a report on a new legislation, there would be two volumes. The first volume will simply contain the rationale as to why we are proposing what we are proposing, and the volume two will be the actual draft of the law which they are suggesting. JJ Irani committee report, where there are two volumes, the answer is no. There was there was no volume. There was only just 105 pages report, because they were not proposing a new legislation. They were simply saying that what should be there in the new legislation. So there are no two volumes. But if you read the BLRC report, that is Bankruptcy Law Reforms Committee, or FSLRC, Financial Services Legislative Reform Committee report, there is part 1 and there is part 2. Part 1 will contain only the principles, only the logic which they have utilized, and part 2 will contain the actual draft of the law. So that is something which you should remember. Means that will help you how to start reading. The report was submitted in the month of November 2015. That will be the date of the report. So there is always a covering letter. Covering letter is written to the minister who is in charge of the ministry which commissioned that report. So this was written to Mr. Arun Jaitley, who was the then finance minister and the minister of corporate affairs. The group was constituted by the finance minister. Hence, this was written in the capacity of a finance minister. Means, had the group been committed by the minister of corporate affairs, they would have used the designation that the minister of corporate affairs. So that is the thing. Uh, So, as I said, there are two volumes. We are just going to read the summary from volume 1. We are not going to read the entire reports. The chairperson is the person who signs at the top, and then the other members sign. If a member has not been able to attend any of the meetings of the committee, then he recuses himself. They just put an asterisk there and simply say that this person never attended any meeting, so he is not signing the report. Because if you don't attend anything and if you still sign, that means that you are prejudiced. Whatever you are, the majority are saying, you are just saying yes to that. So that is something which you should and that is something which doesn't happen. In any report, the order which constituted the committee and reconstituted the committee, that is attached at the end or at the beginning. So the order which constituted this bankruptcy law reform committee, then that committee, that order is attached at the end of the report in this case. In most of the other cases, it is attached at the start of the report. So that simply gives authenticity to the report, that yes, this was actually commissioned by the government and we are working as per the mandate which was given to them. In content, of course, there would be acknowledgements, then there would be executive summary. Executive summary is the most important part. That summarizes the key proposals uh, in the entire report. So if you are short on time, or rather whenever you are reading a report, just read the executive summary first. Then if you find something interesting, then go back to that particular topic and then read that topic. Otherwise there is no need to read every single topic just to come up with something which may suit you. Then they have given the economic thinking as to why we are proposing this insolvency and bankruptcy code, like how the lending should improve and how the banks should be protected and how the lending rates should come down, because lending rates are high because the risk premium is high. Risk is high because the insolvency process is not properly set up or properly operating. So these are all the problems that this code has tried to overcome. If you look at the websites of IBBI publishes monthly reports of how the proceedings under the code are going on. So by and large, it's a good piece of legislation which is working quite efficiently. Means there are of course a lot of troubles as to the excessive role given to the tribunals or the way tribunals are functioning. But of course, these are the troubles which is present in every single legislation. Even in the Companies Act 2013, there are n number of problems which the Act contains. So it will not be possible to address all of them. So that's why the Act has also been amended almost 2 to 3 times later on. The Insolvency and Bankruptcy Code, even if it was just a 2016 legislation, so it still underwent 2 to 3 amendments, and various aspects were changed or added. So which we will keep on looking at them later on. So that would be the executive summary which we are going to read today. Then there would be economic thinking as to why uh, the present arrangements are falling short of what is the expected standard and how we can increase the standard. Institutional infrastructure. So IBBI is that insolvency regulator. Then they are talking about the adjudicator. Adjudicator would be the NCLT or the DRT. The bankruptcy and insolvency information utility, that is IU information utility, that is the NESL for the today's time. Then there are insolvency professionals, where you are going to talk about what role an IP is required to play and how he should conduct himself. The process for legal entities are of course companies and LLPs, and what should be the process for them, what should be the process flow. Then there should be a fast track insolvency resolution process, so on and so forth. Then there is chapter 6, the process for individuals. In the process for individuals, there is applicability of the code, when their insolvency is triggered, and how the process is carried out and how the final orders are passed. There is also a concept called as fresh start. So fresh start is where you dissolve that person from the liability to repay the debt which he has taken, and he can start afresh with whatever he has or whatever he wants to do. Then there is a discharge. Discharge means, as we had discussed earlier, that it's an opposite of charge, and it simply means that you can go and there is nothing which is pending against you now. Then there are repeals and savings, which simply talks about which laws talk about the insolvency and bankruptcy code and how it has amended the other legislations. Laws that many impact procedures under the proposed code. And suppose you want to sell the land, then you will be required to know the income tax and stamp duty implications, so on and so forth. So that is the a simple list of what you should know whenever you are undertaking anything. Interfaces with the Indian draft of the Indian Financial Code. This is again useless. It will be very hard. It will be a political suicide to push this bill. So I don't think it will be presently pushed a lot. There would be other amendments which are now being made, like even the financial service providers are now covered under the insolvency and bankruptcy code. The earlier rationale was the financial service providers stand in a unique position to both the company, to both the economy as well as the um, society. So because if a financial service institution falls, then it takes down almost everyone with them. The deposit, the person who has given the deposits, the person who has taken the loans, the person who has kept something in the locker. So that has a very widespread repercussions. Hence they were trying to treat them differently, but now due to the delay or the inability of or the lack of political will, they are trying to bring them under the framework of the insolvency and bankruptcy code, just to make sure that it it takes care of itself. Implementing that, how you should implement in the annexures, there you will see the office orders which are setting up the committees, they are mentioned. So let us go back to the executive summary, and we will read only the executive summary. That will give us a fair understanding of what was, what is, and why it was put into place. So first and foremost, they are stating that the limited liability company is nothing but a contract between the equity and debt. So equity will be in charge as long as the debt is serviced. But the moment debt is not being serviced, equity should not remain in charge. The persons who have given the debt, they will be put into charge. So that is the entire philosophy behind the insolvency and bankruptcy code. So the moment the insolvency resolution process starts, that order of starting the resolution process, that itself operates as a discharge order to the board of directors and all the employees of the company, unless for the employees, of course, the business is required to be carried on, but all the directors are required to go no matter what. So hence that is the balance which the IBC wants to make, that whenever you are servicing the debt, whenever you are paying the interest on time, great, you will be in charge. But if you are not able to, then no, they will be in charge now. That is the difference which the IBC seeks to make. When creditors know that they have weak rights resulting in lower recovery rate, they are averse to lend. So that is what they stated, that this enactment of the insolvency and bankruptcy code will speed up the recovery, it will speed up the economy, and then the bank will keep on lending the money. It will be a kind of a virtuous cycle. What they stated is that banks are not ready to lend because they don't have any recourse if the person does not pay. Now they are giving them recourse of the insolvency and bankruptcy code. Hence the loan transactions should increase now. That is what they thought. So the problem statement which they have given is that problem statement means what they are trying to achieve, what they are trying to solve. So there are different legislations for bankruptcy, insolvency of the persons, firms, and companies. So that is what they want to unify. So that is the problem statement, and they are going to design a code to unify everything. The key economic question in the bankruptcy. So what happens that when you go into bankruptcy, so that they have stated that that will be decided on case to case basis based on the magnitude of the case. The code is basically an enabling framework that you should always remember. The code will not talk a lot about how do you structure a particular transaction, but the code will talk a lot about what principles you are required to follow. That is again the same key takeaway that you should be remembering. So the next point of the committee was the insolvency resolution process. They gave right to all the creditors, the financial creditor, the operational creditor, as well as the corporate debtor himself, to initiate the corporate insolvency resolution process. Earlier that was not the case. So whenever you wanted to make an application, then you had to fulfill certain criteria, or the company itself had to make that application. So that process is negated by the provisions of the insolvency and bankruptcy code. So the strategy which was proposed by the committee was the default. When the default takes place, the IRP can be initiated and run for as long as 180 days. The IRP is overseen by the insolvency professional, who is given substantial powers. So the powers will vest with the insolvency professional. He will conduct the meeting, and he will administer all the assets of the company. While the IRP is in process, the law enshrines a calm period where the creditors stay their claims for a period of 180 days. So calm period means what? During the moratorium period, no one is going to sue you. That is the calm period. So you can calmly focus on how to come out of this, rather than simply focusing on who is to be repaid first. That is the logic. So this 75% has been brought down to 66%, that I will tell you whenever the time comes. The approach has many strengths. That asset stripping by promoters is controlled after and before the default. Asset stripping basically means that they are selling the asset just to make money for themselves and dupe the shareholders. So that is prohibited. The promoters can make a proposal that involves buying back the company for a certain price. However, after the introduction of the latest amendments which talk about uh, the eligibility of the resolution applicant, this provision has been negated. So it is now no longer possible for anyone to be a resolution applicant. You have to be an unrelated party. And of course, a promoter can't be an unrelated party anymore. That is the point which you should remember. What they stated is that once you always have a stipulated period which cannot be extended, then you will expeditiously deal with whatever resolution you want to do, and you will find a solution quickly. However, again, how the law is playing out in practice is different from what the law says in theory. So the cases are never finished on time, and the NCLTs don't have a lot of time in the first place, and hence the cases remain pending. So, because of the sheer volume of the insolvency cases, even the company cases, which are supposed to be dealt with as expeditiously as possible, even they remain unheard and they remain undecided. That is the problem which we face in today's scenario. Liquidation. So liquidation, that whenever the insolvency resolution is not happening, you can go for liquidation, and liquidation could even be voluntary. Also, the role of the resolution profession is going to remain the same. That you need not read. So firms can be liquidated, but the individuals cannot. So the significant process is envisaged for default by individuals, that includes the concept of the fresh start. uh, So fresh start basically means that whatever your qualifying dates are, don't pay them anymore. You will be given a fresh or clean slate to start with, and you will get a chance to start your business afresh without having to worry about the repayment of the debts. That is the one point. Speed is of essence. So these the drafters and the government officials both are of the opinion that the speed is of the essence, but the Supreme Court has stated that even the 14 days period given to the adjudicating authority, that is NCLT, to decide on the matter, that is not being valued by the NCLT, that is not being followed by the NCLT. The NCLAT is much angry, but it is pretty much helpless in this regard. So that is how the calm period will operate as far as these provisions are concerned. Identifying and addressing the sources of delay. So sources of delay means what? Like, you need to prepare the list of assets, you need to find the buyers, you need to sell them to that. There are of course advertisements which are required to be given, claims are required to be invited, claims are required to be vetted. All these things the resolution professional will do. That is the point of having a resolution professional in the first place. And the second important source of delay is the adjudicator mechanisms. In order to do this, the committee recommends that the LCLT and DRT be provided, etc., etc., etc. So here they were commenting that please give more resources to NCLT and NCLAT to make sure that they are in a position to meet the obligations. The need for a regulator would of course be IPPI. IPPI issues guidelines, IPPI issues regulations, IPPI frames the rules, but the rules are of course issued by the ministry ultimately. And the IPPI is extremely proactive with its circulars. So the IPPI is all in all a good regulator. It conducts the disciplinary committee proceedings and other proceedings also. So these are some of the points that you should remember about IPPI. Who is the current chairman of IPPI? No? Dr. M.S. Sahu. He was earlier a secretary of ICSI. Then he went on to the Competition Commission, and then he has now become the chairman of IBBI. So it's a good call they have taken. From ideas to implementation. So ideas to implementation, they are simply talking about the volume 2, that is the draft which they have given, and they are saying that what we have included in the draft, what we have not included in the draft, so on and so forth. So here we are talking about the cross-border insolvency. So the committee stated that it's a very detailed issue and we can't deal with it within the given time frame, so it should be reserved for some other committee. That is what they said. That other committee was established, they have given a report, and on that report no action has been taken till date. So it has been almost a year, I guess, almost a year, but no action has been taken till date. So we are not very sure about how the cross border insolvency will be handled. Presently what is happening is you go into that country and follow that country's law and get your assets. That is how it is happening in today's scenario. The conclusion, in conclusion, they are saying that yes, the failure of business is crucial, that you won't get the right uh, you won't hit the right business model unless and until you fail. And here they are saying that failure should not be a stigma, so there has to be insolvency resolution. Once you resolve the insolvency, then you are good to go and good to do whatever you want to do. So that is what they are suggesting for conclusion. So I think with this we will stop here for the day. From tomorrow onwards we will begin with the first chapter. The first chapter is with reference to the again the basics, and what are the authorities and how they are to be, means what functions they perform, and how to adhere to whatever the norms they have prescribed. So that is there. Again, Ramaiya is only for the Companies Act, so Ramaiya won't be very useful. Guide to Company Law Procedures, again not very useful. Taxman Master Guide to the Companies Act, just don't refer to that Taxman book, just refer to the ebook MCA. Kataria, this is a referencer, so referencer won't help you a lot. Sridharan and Pradhan. This is a actually good book on takeovers and mergers. So if you want to read more about takeovers and mergers, it is good book. ICSI handbook I had seen, I did not like that. KR Sampath is again a very celebrated author who writes nicely on mergers and amalgamations. Ramanujan, honestly speaking, I have not read that. Uh, Ray's book on mergers and acquisition strategy, that I don't think will be very relevant to you, because earlier the subject also contained the valuation part. That valuation part is no longer there, so you won't be required to study that. As far as the websites are concerned, except SEBI, all the websites are very important for the insolvency resolution also, the IBBI website being the most important. So this is the brief introduction to your subject, what we are going to study, how we are going to study. Any doubts which you have on today's topic? No? So then we will start from tomorrow with the first chapter. The first chapter will again be introductory. The first chapter we will again thoroughly study, and then we will increase the pace. So thank you everyone. Good day. See you tomorrow the same time.